name is Heather Hooditwin. Today we have a very special interview. Our guest today represented himself at the Supreme Court of Canada, the highest court in our country. His name is Michael Alexander. Michael is currently a lawyer. Back in the early 2000s, he was involved in a lawsuit in the area of insurance law. So welcome, Michael.
Thanks, Heather. Great to be with you.
So tell us a little bit about the lawsuit that you're in.
Well, I made an early exit from Bay Street in my practice career and got involved in some business activities where I used my skills as a lawyer, but essentially they were investment activities. And one of the ventures was a mortgage fund that was based in Ontario, mostly in southwestern Ontario. And we had a property there that burned to the ground. And we were fully insured by State Farm US. And we held the mortgage on the property. And State Farm refused to pay out. And the Royal Bank also held a mortgage on the building, and they refused to pay out to the Royal Bank. And so I said, well, I do have a law degree, not in my backyard, so I guess I'll have to take you on this because I don't think I did anything wrong. But I was pretty frightened the day they said they weren't going to pay out because I'd essentially got a lot of my investment funds based on confidence in my judgment. And I have my own money in it too. But a big loss on the books in a situation like this would probably rattle people's confidence. And I didn't want that to happen. So anyway, I ran to the law library and looked into the case law around this issue. And I found quite quickly that State Farm really didn't have a leg to stand on. And so I decided to go after them. And I felt I really didn't have courtroom experience at that point in my career. So I felt it was better to ask some friends at McCarthy's to help me. So I did the basic research. I developed the litigation strategy, which was based on summary judgment, which you probably talked about in some of your videos before. Yes. Okay. So for the audience that doesn't know, summary judgment is you sort of admit to all the facts that the other side is using against you. You say, that doesn't matter. I still get to succeed on the law. So that really, it takes out the discovery process, and then you can just kind of go to court and debate the legal issues. So I recommended a summary judgment strategy. We did that, and I had a lawyer from McCarthy's represent me in the courtroom, and we won. But then State Farm appealed. We went to the Court of Appeal. I drafted the strategy again. I let the lawyer argue for me again. But the lawyer for the banks, who were still in the litigation, and my lawyer did not bring their A games. And we lost badly. And all of a sudden, I was looking at paying all of State Farm's fees, and I was going to lose the money on this property, and so on and so on and so on. It became a pretty significant amount of money, relatively speaking. So I just fired everybody, and I made a personal application to be heard by the Supreme Court of Canada. And they accepted my application. In fact, they did so on an accelerated basis. And all of a sudden, I found that the first case I was going to truly litigate as a lawyer was before the Supreme Court of Canada.
Seriously? That was your first case, like kind of as a litigator?
Yeah. Well, a lot of people said I was crazy. The lawyers, my friends at McCarthy said, you are nuts. Said, I had a classmate there who was engineering this assistance I got. And he said he would phone me up and say, you can't do this. He said, even experienced lawyers, their first time they go to the Supreme Court, they often fall apart. Like you're not going to be able to do this. Right? Yeah. And then I had other people, kind of supporters on the margins, who were kind of like skeptical, and so I was kind of standing alone on this one. But I was very confident that I'd figured out the law. And that I had the right to succeed. I was also confident that this was an issue that could affect investors all across the country, and the Supreme Court would want to hear about it. Yeah. So I just proceeded on the basis that this was a public speaking event, because at that time I had a best-selling book out there, and I was working also as a professional public speaker, and so I was traveling around North America, giving speeches to large audiences. And so I thought, well, you're going to the Supreme Court; it's just a different audience.
Okay, I have to ask you, what is this best-selling book?
Oh, that was How to Inherit Money.
Right. Okay.
Right. and so I watched lawyers at the Supreme Court on TV, because CPAC runs the Supreme Court hearings every weekend, And I watched what different lawyers were doing, and my thought was, well, I can do better than that.
Oh,
Like, and I felt a lot of them made serious mistakes of protocol in dealing with the Supreme Court, and I thought they made serious mistakes in terms of communication strategy. So I was looking at this whole thing as a giant communications event where I had a particular audience and I had to defend an idea. I'm familiar with that territory as a former academic and as somebody who's a professional public speaker, because as a speaker, you get taken on by people in the audience, sometimes in front of thousands of people or on television before, very large, groups of people. So I wasn't afraid of that.
wow.
But I looked at these other lawyers and I just said, okay, I'm not going to do that or that or that or that. Or if saw somebody who did something right, I said, okay, I'm going to do that. Right? So by the time I got there, I felt that I could do what I set out to do.
Okay, so wow. Now I understand that in order to be heard at the Supreme Court, you first have to get leave. Were
Right.
you responsible for those arguments as well? Did you represent?
Yes, I made the application. So there's there's a separate application to get permission for the court to appear.
Right.
And that's a really fascinating part of the Supreme Court, because they only accept about 10, 11% of the applications they receive every year.
Right.
So they get 700, 800 applications, maybe more.
Mm-hmm.
So your odds of being accepted are not very good. But the court, by statute, uses the standard of national importance.
Right.
That's the standard they use to assess your application. So you can make any kind of argument you want in the application. It doesn't have to be a strictly legal argument. The court is interested in knowing why this case is important to the entire nation.
Okay.
Right.
I want to stop you right there, because I think it may be confusing for people to distinguish between any type of argument versus legal argument. What exactly do you mean by that? What is the difference?
Okay. So the Supreme Court, for instance, so I'm defeated at the Ontario Court of Appeal. The Supreme Court does not care about the legal arguments in the case. They don't care, they really don't care. They'll get to that, but they have another concern before that. You have to show that the case itself, in its facts or in the legal issues that were raised, regardless of the outcome, mm-hmm. that they somehow have an impact on the national interest. Mm-hmm. And that the case as a whole presents problems that need to be solved from coast to coast, so to speak. So they want to see that the impact of this decision, regardless of whether it's decided for or against you, that it will have an impact on the entire country. Mm-hmm. Mm-hmm. And so that's a tough standard to meet. Mm-hmm. And I read something I forget whether it was by Justice Wilson or Justice LaRue Dubé, but I read an article in preparation for this where the justice said that we're 25 years into the charter and lawyers still don't understand how to write an application. And I understood exactly what she meant, which is that they're appealing, saying, "Oh, the Court of Appeal got it wrong. They should have looked at this case, and they made they zigged when they should have zagged in the reasoning. And so, you've got to take a look at this." That is not what the court is interested in at all, right? And so, I understood that the application is not to be written in as if you're a lawyer arguing a case. It's to be written by a citizen, drawing the court's attention to any problem or issue that could affect the whole country, whether the case is decided for or against me. And so that there's tremendous freedom in that, because you can point to some issues of law that may be common to all the provinces, but you could use sociology, statistics, political philosophy, history. I mean, and so that was just kind of made for me, because I like that kind of creative problem solving, where you can pull pieces of the puzzle together from different areas. And so I kind of felt like I was born to write that.
Well, you're a scholar.
I was sort of a scholar, yeah. But it was really kind of a combination of my experience being involved in public policy and politics and being a scholar. It's kind of everything I've ever done including playing secret agent when I was a kid, was brought into that, kind of everything I had, and it was accepted. And so that was the big accomplishment.
That's
Is
amazing.
you know, I felt if I just got the application accepted, that would be a huge accomplishment in itself.
That's right. That's right.
So my approach to this entire thing was irony. So I tried to win strategically on irony, to appear not competent, to appear less than I was, to at every point possible make State Farm and big insurance generally, which had an interest in the case. It wasn't just State
Right.
Farm.
Of course.
And with State Farm US, by the way, I mean, that's a big company. It's the 19th largest company in America. Just to make them think that I'm a pushover and they're just going to come into the court and roll over me.
Right.
Right. And so I did a whole lot of things like that to discourage interest in me, discourage interest in what I was doing, and so on. And then, you know, when it came time to go to the court, I had particular strategies as well. For instance, I allowed my law society membership to lapse. Okay, so that meant I could appear before the court without robes because I wouldn't be a member of the bar. So I could appear as a citizen against the big bad corporation, not a lawyer against the big bad corporation. Okay, so I wanted to create that drama in the courtroom to put them off balance. Another thing I did in that regard is that I called up the court. I asked them if I could appear in the courtroom the day before the hearing to check out what it was like.
Yeah.
Also, that meant that I could check into the court the day before, so I would not encounter State Farm or the bank's lawyers before my appearance, because I didn't want them playing head games with me. So I went into the court, got comfortable with the courtroom itself and how it's laid out, because it's much different in person than it is on TV.
Yeah. Yeah.
And then I didn't show up early in the morning to check in. Everybody thought I had chickened out. And then instead of going into the main courtroom or the waiting area, I asked the registrar if I could be given another place to prepare myself to go into the courtroom.
Right.
So when I arrived that morning, I was escorted to another room, which turned out to be the men's public washroom. And so I got a little chair near the urinals where I was going through my, and nobody knew where I was.
Oh.
Okay. So I was trying to create a certain, you know, I just wanted them to think that I chickened out, that I was afraid to go into the courtroom. And then like about a minute before the justices appeared, I ran up there and got into the courtroom and took my place.
Wow.
So I did a whole series of things like that. I won't go into it in great detail,
Right.
but it was just part of an overall strategy to just make them think that I was not up to the task.
Right. Yeah, because sometimes one of the biggest mistakes that you can make as a litigator is to underestimate your opponent.
Right.
Somebody told me that. Do you have any preparation tips for young lawyers before the hearing?
Yes. Yeah, I do. A lot of my I approach the Supreme Court case. In fact, I approach all cases from probably a different standpoint than most people. I do, my primary focus is communication.
Okay.
So what I'm trying to do is take the technical language of the law. Well, let's put it this way. You have a particular audience. It might be a certain level of court, it might be a certain judge or a certain panel of judges, or it might be a tribunal, or you're going to have a different audience depending on the situation.
Right.
And you know, what I have to say about that is that you want to be as clear and concise as possible, and you want to speak in clear English and get outside of your technical language, right? Because too many lawyers stay within their legalese, and I actually don't think that's helpful. And in fact, if you get outside your legalese and express your key points with real rhetorical force, you will be more effective than the person who is, you know, using every technical term in the book. And actually, a really good judge will like you to unpack the technical language and explain what it means. And in fact, that's really what a really good law professor does too. It unpacks the technical language of the cases and explains what really is going on.
Oh, that's interesting.
And so I think, so from that standpoint, you want to be clear, you want to be concise, and get outside of the technicalities of the case in a certain sense. The second thing is that I take this from having been a competitive athlete, is that using vision techniques is very helpful. So in other words, so imagine yourself in that particular forum. Like if you happen to know what the courtroom looks like, think of yourself there. And when you're practicing your remarks, stand up and stand as if you're at the podium and look straight ahead as if you're looking right at the judges. And imagine when you're practicing, imagine yourself in that situation that you're going to be in, so that when you get there, you've already made your mind comfortable with the entire situation. And that will actually improve your confidence in your presentation, because actually your physical and your visual cues, when they line up with what you've practiced, will come there and assist you in the moment. So those are two things that outside the fact and outside the actual legal arguments that I think they're indispensable for effective advocacy. And that's the way I approach every case.
That's really interesting. So yeah, it doesn't matter. We're not talking about just Supreme Court cases. Like, if you have an Ontario Superior Court case, you can just go visit the courtroom just to get the lay of the land. But of course, nowadays with COVID, there are a lot of virtual hearings. So maybe
but sometimes you can just look at pictures if you can't. But as I say, with the Supreme Court, like on the Supreme Court, it looks like the judges are way down here, like way down in front of you, and you're way back there, and they're up high and you're low.
Yeah.
That's not true at all. And I was actually had a moment of terror when I went into the Supreme Court hearing chambers the day before, because I got there and I stood at the podium, and my God, there's very little distance between you and the judges, and they're almost on the same level as you are. And I just thought, wow, they are going to be right in my face.
Oh my goodness.
They are right in your face. And so that's something that took me the entire evening to get used to that, because I had not been envisioning it that way. I saw it on TV and I looked at it like this, but actually it's like this, and so I readjusted my imaginings of what it would be like and got used to it. And by the morning I was ready to go.
Oh my God. Okay, that's really fascinating. Do you have any more tips in terms of preparing yourself before the hearing?
Yeah, I mean, there are a few things. Don't have milk products 6 hours before your appearance, because your throat will get chalky. Okay. And your throat will get chalky, and you won't be able to you will not speak as well. Also, don't drink coffee 6 hours before an appearance, because it makes your vocal cords constrict and your voice will not be as resonant.
Wow.
All right. So stick to water if you can 6 hours before.
Right.
And also just, listen to yourself, like use your iPhone, like record what you're saying and listen to yourself. Right. And if it's really an important hearing, get together in a boardroom with a bunch of colleagues or friends who want to, and practice right in front of them, and have them critique you afterwards on everything, the tone of your voice. And so I did that. I did that in a friend's boardroom. So that was helpful to me as well. Although I didn't in the end get any comments that truly helped me, but it helped with my confidence that there wasn't really anything negative that was said about what I was planning to do.